Thanks once again for joining me on Freedom is Scary Live. This is episode number 20. More freedom for the American individual is always the answer to the problems in our country. Not more laws. We don't need more laws. We don't need more police. We don't need more prisons. We need more freedom. That is always the answer. So why is freedom scary? Because it's through the guise of safety that we, the people, lose our freedom, lose our liberty. Professor Jonathan Haidt said, "In America, we say if anyone gets hurt, we will ban it for everyone, everywhere, for all time. And before we know it, everything is banned." President Eisenhower said, "If you want total security, go to prison. There you're fed, you're clothed, given medical care, and so on. The only thing lacking is freedom." And this video is about excessive force. It's not about a lot of the lockdown restrictions that we've had, but that's exactly how we could cure all this COVID stuff. Is we can create a nice little bubble, a nice little cell to put every little individual in, and we can feed them through a tube, and we can keep you alive. But the goal of humans, and really our country as Americans, hasn't been just to survive. We've wanted to thrive. That's what the American dream's about. And that's why we are who we are. So again, this video is about excessive force. That really has been my primary practice area, at least the past 10 years or so, if not 14 or 15 years. I've done a lot of federal civil rights litigation over the law of excessive force. And from the little unscientific poll that I ran on my YouTube channel, that seems to be the topic that people want to hear about, is the laws pertaining to excessive force. Okay, so obviously, excessive force has been in the news recently with George Floyd, with really, you name the litany of cases where there's been a police shooting. Police shootings are judged under the same legal standard as police beating cases. And this is what I'm referring to as the law of excessive force. And I'm going to sort of just lay the basics out, because it would be hard to explain in one lunchtime video everything you need to know about excessive force. But I can explain the basic structure of the law so that you can understand the concepts. So it's been in the news, and as I explained in my last video, qualified immunity has very little relevancy to excessive force. That applies more often to search and seizure type cases than excessive force cases. And if you want to watch the last live video I did, episode 19, I discussed why that is under the topic of qualified immunity. Generally, Section 1983 of the U.S. Code is what allows us as individuals to sue the federal government for violating our civil rights. That's, if you've ever heard the term a Section 1983 lawsuit or 1983 claim, that's what they're referring to, is the ability of the citizen to sue a police officer or other government officer or employee for violating our civil rights, a federal civil right. So it could be a federal constitutional right, could be a federal statutory right. It generally doesn't apply to state law rights or state created rights. Now, when we talk about filing a federal civil rights lawsuit, that's what we're talking about, is a Section 1983 claim. And you can file them in any state because they're under federal law, though the laws may be slightly different because you have different federal circuits. So where the U.S. Supreme Court hasn't ruled on something, you look at next to your federal circuit law. In West Virginia, where I am, we're in the Fourth Circuit, along with Virginia, Maryland, North Carolina, and South Carolina. So you look first generally to figure out what the federal law is on something, first at the Supreme Court, and then you look to your federal circuit. And if you don't find something there, you look at other federal circuits. Then you can look at the federal district courts, which are the trial court levels. Something that most people don't understand, and this kind of goes along with qualified immunity, is that in these lawsuits against police officers for federal civil rights violations, is that you have to sue the individual. You sue the individual officer. You don't sue the employer. It's not because it wouldn't be better to sue the employer, but it's because that's the way the law is written. That's what we have to do. So if Officer John Doe commits excessive force and I go to sue Officer John Doe, it's me, the plaintiff, versus John Doe, an individual. And I usually even write that in, an individual, because a lot of people who are suing police officers for the first time, talking about lawyers even, they'll put, in his official capacity as a police officer for such and such department, and then boom, they get dismissed following the defense lawyer's motion to dismiss, and that will get dismissed because the claim is not against the employer. There is no vicarious liability like you have, say, in a car wreck case where an employee gets in a wreck and you're responsible for your employee. It doesn't work that way. So you sue the individual, and 99 times out of 100, the employer picks up the representation and has an insurance policy, but you're always suing the individual. There are times that you can sue the employer if it's a city or a county, if they have a pattern or practice or an official policy of excessive force, for instance, or other civil rights violations. That's called a Monell claim. But what we're talking about, excessive force for a specific incident between a police officer and an individual citizen, that's always going to be filed against the individual. So as far as the basic excessive force laws, you have a different analysis depending on who you are as the plaintiff. So if you're what I would call just a person on the street, it's actually a Fourth Amendment analysis. If you are an arrestee after a certain point or a pretrial detainee, you have a separate analysis. And if you're a prisoner in prison or in jail as a convicted prisoner, then you have a totally different analysis, and that's under the Eighth Amendment of the Constitution. So it gets very confusing, and it's confusing to judges as well. And there have been federal judges who have gotten these things mixed up and have had to have been corrected on appeal. Take another sip of my death wish. All right, so the guy on the street, the person on the street, that's who we're most concerned with. That's where you have probably your majority of encounters. Now, this could be somebody who is in the process of being arrested, or it could just be somebody walking down the street. All right. The Graham factors. So if you haven't been arrested yet, you're not in custody, you're just walking down the street, or you're about to be arrested, you're protected by the Fourth Amendment. So it's a Fourth Amendment analysis, basically like search and seizure, because they look at it as a search and seizure. And there's a Supreme Court case called Graham versus Connor. I put it up on the screen from 1989. That is the seminal case for police use of force, for excessive force under the Fourth Amendment. So this doesn't apply to anyone in jail or in prison, or really to anyone who's been arrested, who's already, for instance, down at the department being handcuffed or in that process. This is literally somebody before they're arrested, during their arrest, or shortly thereafter the arrest. So these are the Graham factors. This is really the ideal analysis. If you're a plaintiff, this is the easiest case to prove because you have the most rights according to the Graham decision as the guy on the street. You get a few less rights as a pretrial detainee, and you get way less rights once you're a convicted prisoner. All right, so the Graham factors are 3 factors that the court looks at, or that the jury ends up looking at, to apply the facts of the case to the law. So the first Graham factor is 1, the severity of the crime. So the severity of the crime at issue, is it insignificant, or has the plaintiff committed no crime at all? If so, then the plaintiff already has a good claim for the violation of his or her constitutional rights to be free from excessive force. So what was the guy being arrested for? And this is just a vehicle to compare cases, really. Is this somebody who was being arrested for public intoxication, for which under maybe West Virginia state law, there really is no potential jail sentence? That's an insignificant crime. So it's going to be hard to substantiate or justify a greater amount of force that's used on somebody who's being arrested for something that's very insubstantial or insignificant, like public intoxication. Or it could be a basic trespass charge for which maybe there's not even a potential sentence. Or it could be a misdemeanor possession of marijuana, first offense, where there may be no jail time for that. Or is it a case where they've pulled over Ted Bundy in his Volkswagen Beetle and they realize who it is? So those are two different extremes, and a lot of times it's somewhere in the middle. So is this guy under arrest for something that is, violent? Is it something that involves the use of firearms during the commission of a crime? That is going to allow for a higher level of justification of use of force. Secondly, the second Graham factor is whether a reasonable officer would have perceived this person as posing an immediate threat to themselves or really anyone else. So was the person armed? The Fourth Circuit has ruled that where the plaintiff was neither armed nor suspected by the officer of being armed, then that's a much better case for excessive force. So that's going to be the biggest part of the second element of the Graham factors, is was the person armed? In a lot of these shooting cases, if there's a gun present, it's going to be hard to win an excessive force civil lawsuit. If there's no gun present, it still could be a problem for a plaintiff if the police officer has some reason to believe that the person may have been armed. So he could have, a lot of times they'll say, well, I saw his hand go in his pants and he refused to show me his hands. I was shouting, show me his hands. Or is this a scenario where the suspect was already taken into custody? He's just been handcuffed. They pick him up off the ground and he punches him in the face. So those are two different scenarios based on factor 2. Did they believe, or could they have reasonably believed, that he was armed or that he posed a safety threat to somebody? Or did they know for a fact that he didn't pose a safety threat? So if he's already in handcuffs, we know that he's not going to, for instance, open up his nearby backpack and pull out a pistol. So that's element 2 of the Graham factors. Element 3, the last Graham factor, is where a suspect actively stops resisting prior to arrest, where the suspect actively stops resisting prior to the allegation of excessive force, then you have a much better claim to go forward to get to a jury to prove excessive force. So was the person resisting arrest? Or had they submitted? Did they put their hands up? Did they, were they fighting? Were they not fighting? Were they resisting? Were they not resisting? Sometimes it can be hard to tell. I've had many people tell me that I was laying there, they were beating on me, and they were saying stop resisting as they did it. So that, I think, stop resisting has been sort of a training thing, sort of like show me your hands. It's kind of like when somebody taught me once, and I think it was in a firearms or a self-defense class, like it's a good habit to, if you feel like you're about to get in a physical confrontation with somebody or a shooting or whatever the case may be, to keep your hands like that. In case there's a witness, that's what they remember is your hands up. Or if there's a video, you see your hands up. And that's gone into a lot of training. But that's another important way of analyzing the facts of basically weighing a use of force against uses of force against each other to figure out what's justified and what's not justified. So those are your three factors, though that may not help a whole lot. But was the person, did they commit some sort of serious or dangerous or violent crime? Did the officer, any reasonable officer, have some reason to fear for their safety or the safety of someone else? And that's basically a self-defense standard, just like any of us would be evaluated with in a self-defense situation. And lastly, was the person resisting or were they not resisting? So that's your basic excessive force law for the guy on the street or a person who's being arrested up until a certain point. And I'll get to that. When does the law change? But let's look, and you can read about the Graham factors anywhere on the internet. But let me give you some practical points here. What does this mean in practice? The best way to figure out what something means in practice, rather than just reading the law, what I like to do is go look up the jury instructions. I mean, the proof is in the pudding. I don't care what it says in a law school textbook. I don't care what it says or someone says on YouTube or on Fox News or on CNN. If you're interested in a particular case that's already happened, contact the court, go pull the jury instructions that were actually used. So here's an example jury instruction that I've used in a Fourth Amendment excessive force case that actually has been read to the jury by the judge. So a lot of times when the judge is evaluating an excessive force allegation, generally the judge isn't deciding the entire case. The judge is just a gatekeeper to the jury. He or she is deciding whether or not there's enough evidence, the allegations are bad enough to allow the case to go to trial. And as I explained in the qualified immunity video, that's why excessive force cases are much, much more likely to always go to trial and to never be subject to qualified immunity, at least where you have a plaintiff who is alive and able to testify. So the judge, a lot of times the defense lawyers won't even try to get what's called summary judgment in an excessive force case, because where you have a disagreement of the facts, for instance, he punched me while I was handcuffed, and the defense says, no, I didn't punch him while he was handcuffed, then that's not a legal issue. That's a factual dispute. That's going to go to trial. So you're more likely to go to trial. And so in the end, it's going to go to a jury of 8 individuals, 8 people. They're going to be read instructions by the judge on how to evaluate what they've just seen at trial and how to evaluate whether or not that's excessive force. So here's an actual example from a jury instruction from an excessive force case under the Fourth Amendment. So this is what the judge actually reads to the jurors. The Fourth Amendment to the U.S. Constitution protects persons from being subjected to excessive force while being detained by police. In other words, a law enforcement official may only use the amount of force necessary under the circumstances to detain the person. Every person has the constitutional right not to be subjected to excessive force while being detained, even if the detainment is otherwise proper. In this case, the plaintiff claims that the defendant violated his Fourth Amendment rights when he detained him. In order to establish that the defendant, insert the name of the police officer, used excessive force, the plaintiff must prove the following by preponderance of the evidence. What that means is more than 50.001%. So more likely than not. It's not a criminal case, it's a civil case. So slightly easier burden, but you still have to prove it. One, the plaintiff has to prove that the defendant engaged in certain acts, those being the use of physical force that's alleged to have happened against the plaintiff. And the two, that the force used by the defendant police officer while committing those acts was excessive and thereby were taken in violation of, insert the plaintiff's name, his Fourth Amendment rights not to be subjected to excessive force. And lastly, that three, I can hardly do that because of my arthritis. The defendant was acting under color of state law. So he was basically on duty doing something that he was supposed to do under his authority. So it was a police officer making an arrest. He wasn't like that one case I had where you had a Division of Corrections parole officer making a traffic stop at gunpoint and searching somebody's car for drugs. So there's a color of law issue in that case, which I settled, by the way. But in most cases, most excessive force cases that I've ever litigated that ever end up at trial, almost never is the under color of law issue in dispute. A lot of times we just tell the jury that the under color of law element is not in dispute. Disregard that one. But sometimes it could be in dispute, like the parole officer case I told you about. And then the instructions elaborate just a little bit, and this is where they go over the Graham factors. So the judge tells the jurors, in determining whether the force was excessive, you must consider the following: the need for the application of force, the relationship between the need and the amount of force that was used, the extent of the injury inflicted, and whether a reasonable officer on the scene, without the benefit of hindsight, would have used that much force under similar circumstances. You should keep in mind that the decision about how much force to use often must be made in circumstances that are tense, uncertain, and rapidly changing. You must determine whether the officer's action in light of the facts and circumstances confronting the officer. You must decide whether the officer's actions were reasonable in light of the facts and circumstances confronting the officer without regard to the officer's own state of mind, intention, or motivation. In making this determination, you may take into account the severity of the crime at issue. Here are the Graham factors, if any, whether the plaintiff posed an immediate threat to the safety of the defendant or others, and whether the plaintiff actively resisted arrest or attempted to evade arrest by flight. So I believe that these come from some form jury instructions that various circuits use. But you can see that it's difficult to try to explain to a jury what the law is as far as in excessive force. So they've tried to word it in such a way to explain to them that we're not judging in hindsight. You have to understand that decisions sometimes are made in a tense moment that are uncertain, rapidly changing, but then they're asked to consider whether that force was really necessary, whether there was some relationship between the necessity and the amount of force used, what kind of injuries were inflicted. So if the crime was insubstantial, that was if it was a traffic, or if, say, jaywalking, all right, if it's a jaywalking and he was going to try to give him a jaywalking ticket, but he ends up, fracturing his spine in 3 or 4 places, then that's going to, if you read these instructions, the jury is going to be able to evaluate whether it was necessary to use that amount of force to do what the officer had intended to do. So in the end, there's no good way of doing it, but they're officially guided by the Graham factors, severity of crime, whether there was an immediate threat to somebody. And that's kind of what it all falls back to, is a basic self-defense analysis. So was this person a threat to me or to someone else? Or were they not a threat? Because part of that is going to be, well, why were you interacting with the person in the first place? So is this somebody who was being arrested on serious violent felony charges, or is this the guy jaywalking? And lastly, the jury instructions say, if any of the above elements has not been proved, then your verdict must be for the defendant police officer. So that's in practice exactly what a jury is instructed. And that's after they had just watched the trial. So they had heard all the testimony of the witnesses. They had seen the video, if there's a video. That's the Fourth Amendment. That's for the guy, again, the guy on the street. Okay, now let's look at pretrial detainees. So pretrial detainees, it's sort of questionable when you become a pretrial detainee. So at the moment that you're arrested, you're still the guy on the street. You're still under the Fourth Amendment. When you're put in handcuffs, you're still the guy on the street. You're still under the Fourth Amendment. And probably when you're put into the back of the police cruiser, you're still under the Fourth Amendment. At some point, and this is where you want to look at the Federal Circuit case law that can be different depending on where you are. At some point, you then become a pretrial detainee, usually between the place that you were arrested and the police detachment or the police department or the jail, wherever you're going to be fingerprinted and processed. No doubt, whenever you get to the spot where you're going to be photographed and fingerprinted and processed, at that point, you are a pretrial detainee. So if you have some sort of use of force situation or a police beating situation that occurs during the processing, almost always that's going to be a pretrial detainee case, and that is no longer under the Fourth Amendment. You're under the 14th Amendment due process clause. And it might not make a whole lot of sense to most people, but it's just one of those confusing areas of the law. And again, federal judges and many lawyers have gotten this stuff confused. And this, you're going to like this, because this, you had at least somewhat of a common sense explanation to the jury under the Fourth Amendment. Now you'll see that you have a slightly less easy task to prove excessive force to a jury. So to succeed on a federal excessive force claim under the due process clause of the 14th Amendment, plaintiff must show that the officer, quote, inflicted unnecessary and wanton pain and suffering on the individual. So what does that mean? It's usually a balancing test. Here in the Fourth Circuit, we have a balancing test that consists of, this is what the jury is supposed to weigh: the need for the application of force, the relationship between the need and the amount of force used, the extent of the injury inflicted, and whether the force was applied in a good faith effort to maintain and restore discipline or maliciously and sadistically for the purpose of causing harm. Now, some of that actually came from the Fourth Amendment analysis. There's about a sentence in there that comes out of the Fourth Amendment, but it sort of gets even more confusing from there. Under the 14th Amendment standard, a plaintiff must show that the defendant inflicted unnecessary and wanton pain and suffering upon the detainee. So what does that mean? The issue generally is whether the force was applied in a good faith effort to maintain or restore discipline, or maliciously and sadistically for the very purpose of causing harm. So there it is. Do we have a good faith effort to restore some sort of discipline that's gotten out of hand during the pretrial detainee process? Or is this just some sort of punishment that was inflicted on the pretrial detainee. And this is where it's hard to quantify what happened. So I had multiple cases out of one city in West Virginia that all came from the same video camera. And this was in a holding facility. And I had 3 or 4 cases from this one holding facility. And this was in Parkersburg, West Virginia. And what you would see is the detainee, the arrestee. I mean, he hasn't even been taken to jail yet. He just got arrested. And then you see a confrontation with the police officer. So is there some sort of conduct by my client, by the plaintiff, that necessitated the force that was about to happen? And that was the issue really to go to the jury in cases like that. Do you see any resistance start up by the guy who got arrested? Are his hands up? Is he handcuffed? Does he move at all? And in the first case that I tried like this, we played it like 150 times to the jury, and then we would pause it and stop it. And then you'd see, and the tape would skip around, and you'd see the arm come back for a punch, and then it would skip, and then the punch was over. And then you'd see the hands come up for like a choke to choke them, and then it would kind of skip around. Next thing you know, the client's on the ground. And so you kind of have to analyze what happened, to whether or not there was some sort of physical resistance by the plaintiff, or was it just the sort of thing like, what'd you say? What'd you call my mother? And then he punches him. That is what falls into what's not allowed, is where you're just using physical force or violence against the pretrial detainee just to punish them for what they said, or just because you're sadistic or malicious. And it's sort of a, right versus wrong. Was this, was he doing the right thing? Was there a legitimate reason for it? Or was it just to punish them for what they said, or because they don't like the guy? So that's the big difference under the 14th Amendment. But still, we can look at, to see what the practical application is, the jury instructions. Let's see. All right. So what the hell does all that mean? Let's look at the actual jury instructions. These are real jury instructions that have been used. All right. Here's what the judge said to the jury in that actual case, I believe, that I just told you about. Jurors, your verdict must be for the plaintiff and against the defendant police officer if all the following elements have been proven. First, the defendant, insert the allegations of excessive force that we're alleging, punching, choking, whatever the case may be. Second, the force used was excessive because it was not reasonably necessary to punch and choke the detainee under the circumstances. And third, the defendant police officer was acting under color of state law. Like I said, he was on duty doing police stuff. The court continues. In determining whether the force was excessive, you must consider the following 4 factors. 1, the need for the application of force. 2, the relationship between the need and the amount of force that was used. 3, the extent of the injury inflicted. Now, by the way, there is no threshold for that. There doesn't have to be a permanent injury. There doesn't have to be any injury. It's just one of the factors that the jurors are to consider is if there's an injury. Did he walk out of there with a broken back or a broken nose or broken ribs? Or does the evidence show that there were no provable physical injuries? It's not required, but if there are proven physical injuries that are substantial, that helps the plaintiff prove that the amount of force rose to the level of being unnecessary and excessive. The last factor that the jury is to consider is whether the force was applied in a good faith effort to maintain and restore discipline, or maliciously and sadistically for the very purpose of causing harm. There's one more factor. And 5, whether a reasonable police officer on the scene would have used the same force under similar circumstances. So again, these all go back to this objective standard that police officers, even if they have a malicious motive in their mind, it still can be excused under federal law if the not perfect, but the nice guy cop, the reasonable cop, if he would have done the same thing knowing what this guy knew, regardless of what their personal motivations were. So it's an objective standard. So whether that reasonable cop on the scene would have used the same amount of force under the same circumstances. But it's not over. The jury instructions continued. You must determine whether the officer's actions were reasonable in light of the facts and circumstances confronting the officer. You should keep in mind that the decision about how much force to use often must be made in circumstances that are tense, uncertain, and rapidly evolving. An officer is not justified in using physical force against a pretrial detainee solely because the pretrial detainee has verbally threatened the officer. That's an important one. Furthermore, an officer is not justified in punching a pretrial detainee or prisoners in the face. Now, those were specific sentences, I believe, that I had asked for in that particular case. So those might not be in all of them. But that's what federal law was when I tried this particular case, is that, and I believe that is a lot of these are Fourth Circuit specifically. So you have to look at your circuits, but it's clear that in the Fourth Circuit, and this comes up, it doesn't matter what the pretrial detainee says. And in this case, they were saying the officer had testified, and the other officers who were in the room had testified that my client had said basically he was going to go rape his wife or something like that. Now, my client had denied that. That wasn't his story. No. And then he was going to go do something to his wife, which he wasn't married. I mean, he didn't know him from Adam anyways. He wasn't married, but he had said, he was going to do something to his fictional wife. And then he was going to take his badge and shove it up his ass or something like that. Maybe he admitted to that part. I couldn't remember. And then you have the use of force. And so the law is that even if a public citizen is okay, all right, if you say something like that, you expect that you're going to get force used against you. That's not what the law is, though. I mean, when you put on the badge, you're going to be held to a higher standard than just any guy on the street. So even if an arrestee says something like that, which they commonly do, you're expected not to lose your temper and not to retaliate with physical force that's unnecessary. Excuse me. So that was the state of the law. Those were the instructions to the jury. Believe it or not, even though that case was caught on tape, and with those instructions, the jury found the officer not liable. So we lost. We got a defense verdict in that case. But the federal judge threw that jury verdict out and found that, I think he quoted Groucho Marx in that case and said, I'm reminded of the Duck Soup movie with Groucho Marx, where he says, he's got a fake nose and fake mustache on. He says, somebody had said, well, I recognize you. It's you, Groucho. He said, no, it's not me. Who are you going to believe, me or your lying eyes? He said he was reminded of that because we had watched this video. You see it happen on video. He walked out with a broken nose and whatever injuries there were. Yet the jury found that basically there was no physical contact there. And the judge threw that out and found that as a matter of law, this was an excessive force violation, which really I haven't found another case where that had happened. That was an amazing case. It went all the way up to the Fourth Circuit, and the Fourth Circuit affirmed that decision and found that it was an excessive force violation as a matter of law because it was on video. So it didn't matter what the officer said. If they got caught on video doing it, then as a matter of law, if it was excessive force. So we got sent to a second jury trial just on damages. And that was a great jury trial to have, because that's where the jury is instructed, hey, this is a civil rights violation. Your only job is to determine how much money is to be awarded to the plaintiff. A quick word on the importance of video footage. So excessive force cases, a lot of times we do have video footage of what happened. So as I just demonstrated, it is very important, very significant to have video evidence in an excessive force case. So a lot of times what I tell people who are calling me about excessive force cases is I'd like to have a video and provable medical injuries damages. I don't necessarily have to have both, but I'd like to have both. If not, then I need a good one or the other. So either give me no video, but really outrageous damages, or a shooting case or a death. So give me big damages and no video, or give me a video showing a clear civil rights violation, but with very little injuries or damages. So I can't overstate the importance of video footage. And really, there's no excuse for not having video footage now. I mean, we have phones, we have videos everywhere. And a couple stories about this is the case I just told you about. I ended up representing the police officer later, who I'd been to 2 jury trials against, been to the 4th Circuit against. He later hired me to sue his employer, the sheriff's department in a different county, after they screwed him over and had illegally put a GPS tracker on his police cruiser and indicted him for every time that his actual whereabouts fluctuated with his time card. But let's see. The other thing is, all right, Scott versus Harris. That was the United States Supreme Court decision that held that basically when 2 parties have conflicting stories, that if one of them is blatantly contradicted by the video evidence, then the court is free to disregard that party. And that's how I won that case I was talking about, is because Scott versus Harris, 2007 Supreme Court case. These police officers, as I had cross-examined them in front of the jury, they had all sorts of, they were kind of smirking, some of them. And they were like, oh yeah, that wasn't a choke, or that wasn't a punch. That was like a pressure point thing that they teach you in the police academy and blah, blah. I mean, they had like stupid just excuses for what we were seeing on the video. That wasn't, really what we were seeing. But that's not what the law is. If the federal judge wants to, they can just go with the video and disregard what one of the parties testifies to, or one of the police officer testifies to, if it's blatantly contradicted by what you see on the video. So if you catch it on video, a police officer, in other words, can't just say, oh no, you didn't see that. That's not a punch. That was a nothing. Or that was it's not what it looked like. And it is more powerful than the officer's testimony. And that's just the way it is. And really, testimony in general is, it's really bad evidence. It's really awful evidence. When I was in law school doing the criminal law clinic, they basically teach you how to do a lot of basic criminal defense. They did this little session where we all sat in a room and they played a video, and it showed a guy carrying a box, and he delivered a box to a house. You weren't told what it was about. We all watched the same video. And the guy drops the box off at the front steps of the house, and he walks on. They turned the video off and they said, all right, now we're going to ask you questions about it. All right, what color shirt was the guy wearing? So people would raise their hands and the professor would call on you. And somebody would say, oh, it was a red shirt. No, it was a blue shirt. All right, who thinks that he had a yellow shirt? And the hands go up. And out of the room, we knew that we were going to ask questions about it. No one could remember what damn color the guy's shirt was. It's like, all right, did he put the box, which door was it? And nobody could really, there were different people had different opinions on what they had seen. But now, undisputedly, the video showed what it showed. And when they replayed it, everybody who was wrong would say, oh, yeah, we were wrong about that. But in real life, it's not a game like that. In real life, people, even if they're not purposefully lying, they may think they remember things a certain way and they don't. So the point is that testimonial direct evidence a lot of times is very unreliable. It can be very unreliable. And people like to say that what's the word for the other type of evidence? I'm slipping my mind here. Let's see. All right. If I didn't have to think of it, I'd think of it. But say the other type of evidence, which gets knocked all the time, is where, it's not direct testimony. It's not an eyewitness. It's just coincidental, circumstantial. Thank you. Blind justice. Thank you. Appreciate that. Every time I go to think of something, if I'm put myself on the spot, I won't think of it. All right. So circumstantial evidence. All right. You wake up in the morning. You didn't see it snow, but there's snow on the ground. All right. Circumstantial evidence. Is that reliable? Hell yeah. Using another snow example, the next day you open your door, fresh snow on the ground. You see footprints coming up to your door and leaving your door. Did you see, or did anyone see somebody walk up to your door? No. Do you know what happened? Yeah. That's circumstantial evidence. A lot of times circumstantial evidence is much better because there's nothing to screw up. There's nothing to misremember. So circumstantial evidence can be really, really good. Likewise, video evidence, while it can be misleading at sometimes based on angles, or if it's been doctored in some way, or if it's motion activated rather than always on, and I've dealt with that. There can be issues like that, but assuming you have a clear video, a continuous video, it's hard to beat that. And I've used that Scott versus Harris 2007 Supreme Court case many times to argue that courts should go with the video rather than what the officer said. So video is good. Video is good. Another thing that I'll touch on, running out of time here, but that's happening in the arena of excessive force litigation is all this chokehold stuff post George Floyd. It's kind of like, it pisses me off why I made the video about qualified immunity is, we have Congress, we have presidents and ex-presidents always discussing qualified immunity like it had anything to do with George Floyd. It didn't at all. And you can watch that video. I'm not explaining that again. But now we have them talking about chokeholds, chokehold this, chokehold that. Like it has. All right. I've had chokehold cases, and I think that's a misnomer. But I can recall scouring the country's federal case law looking for stuff on chokeholds because I've got it on video. But you know what? There's not a lot of law out there on chokeholds. First of all, what does chokehold mean? And that's the problem, is now we've had all these, President Trump issued an executive order. We've had all these state level executive orders and legislation around the country banning so-called chokeholds, banning the use of chokeholds. We have Delaware, the governor there, executive order, banning the use of chokeholds. We have Iowa, executive order, banning the use of chokeholds. We have, where else? Indiana, banning chokeholds. And then Connecticut, banning well, they got specific. Chokeholds, strangleholds, armbar, control holds, lateral vascular neck restraints, carotid restraints, chest, and they go on. And then we have state and local law enforcement agencies that their use of force policies prohibit the use of chokeholds. and they describe it as a physical maneuver that restricts an individual's ability to breathe for the purposes of incapacitation, except in those situations where the use of deadly force is allowed by law. I'll also note that policies and procedures are not the same thing as the law. So one thing that every defense lawyer gets, an instruction that they get to the jury in pretty much every excessive force case, is an instruction that a violation of their agency policy or procedure is not necessarily a civil rights violation. And that's the truth. So the West Virginia State Police could say that all chokeholds are banned by this department, or they could say that you're never allowed to. Let me use a ridiculous example here. All right, so we don't believe in handcuffing anymore. Anybody who handcuffs any suspect is in violation of this manual and will be terminated following the 6-month ordeal to terminate you. And so somebody handcuffs somebody, they get terminated after 6 months of going through red tape, and a civil lawsuit is filed. Well, that civil lawsuit is going to lose regardless of the fact that the manual says they're not allowed to do that, because that's not federal law. They can put whatever they want in their manual, and it's generally inadmissible in federal court. It's not even something that'll go to the jury. So even if they say, all right, chokeholds are banned, that's not even something that necessarily is admissible, because they don't control what federal law is. And that's another reason why you don't see a whole lot of experts. You really don't have expert testimony on the issue of excessive force. And you might think that that's surprising, but generally we don't bring in police experts to come in and testify, because they can't come in and say, well, I reviewed the video, I reviewed the deposition transcripts, and I believe, it's my opinion that excessive force was used. No, an expert can't say that. Why? Because the court is the expert. The judge is the only expert. The court is the expert on what the law is. No, there can be no expert witness to testify what is excessive force. Now, they could bring in an expert, or the plaintiff could bring in an expert as to police practices, police procedures, but they won't be allowed to cross that line. They shouldn't be anyways, if the lawyers are doing their job, to cross the line into instructing the jury on what is excessive force or not excessive force. Only the court does that. So that all goes into the jury instructions. So it's pretty rare that there are experts, because they can't testify to really what's important, like they could in a medical malpractice case or a car wreck case. And both sides take a huge risk in getting that expert to agree with their facts. And it generally just, it's an extra expense. Ideally, these are all factual cases, factual disputes. Going back to chokeholds, if you even watch the UFC, or if you do Brazilian Jiu-Jitsu, or like me, if your kid does Brazilian Jiu-Jitsu, I did a video on this already once. You know that most of the time what people are referring to as chokeholds aren't even chokeholds. I mean, they're cutting off the blood supply. They're not even cutting off. It's not even about cutting off the air supply. And actually, if you have somebody who knows what they're doing, they're not going to accidentally kill somebody. So it's the guy who has no idea what he's doing, that ends up, choking somebody to death or cutting off their blood supply to death. So I think a lot of people that know how to control people physically and safely, and do it all the time. And again, my 13-year-old kid go out there and gets choked and chokes other kids, all day long, and nobody gets hurt. So I just know that a lot of this stuff is complete BS, and it's done to appease people over the video that we saw in the George Floyd case. And the problem with that, the second problem is if we're going to stop in the end, all this comes down to self-defense. So any chokehold, anything's on the table if it's necessary to defend yourself or defend someone else, whether you're a police officer or anybody. So if I think when they start banning any kind of restraints or that look anything like a chokehold, they're going to take valuable tools off the table for somebody to control, who's trained to control somebody. And what are you going to have? What are you going to have? The law of unintended consequences. You're going to have more people shot to death because the training's so bad, and they didn't know how to control somebody. They didn't know what else to do. So that's just an aside, but that's really I think the changing area of excessive force law is all this new stuff about chokeholds, where for decades before this, nobody seemed to care about chokeholds. And what is a chokehold? I think Connecticut really got more technical with it and more accurate with it, but then they just banned all of it, even stuff that would be completely safe and really, tactically and medically better for everybody. All right. So some of the question, and that's basically the rundown of excessive force law, even not getting into specifics. So you have Fourth Amendment for the guy on the street, 14th Amendment due process clause for pretrial detainees and arrestees after a certain point. And then you have the 8th Amendment for prisoners. I didn't really go over that, but there's not a whole lot to go over it. And I don't do prisoner cases, but that's it. We have 8th Amendment. What does that say? No cruel and unusual punishment. So prisoners, I mean, you're basically screwed. If your lawyer, if you can find a lawyer and prove cruel and unusual punishment based on whatever happened to you, then you can prove an excessive force case. I've never taken one of those. I've taken jail cases, but those, even people in jail, if they haven't been convicted yet, they're still pretrial detainees. We still use the 14th Amendment standard. Once they're convicted and they're prisoners, then they don't have that right. They just have the whole cruel and unusual thing, and that's a completely different area that I don't really practice in, don't have a whole lot of experience in. Let's see, some of the comments I lost track a long time ago. Let's see, not really on what I'm talking about, but Randy, I agree. Turn off your TV. I turned mine off a long time ago. Daniel, I appreciate it. Patrick, seems to me if the victim doesn't have a gun, the cop used excessive force. Well, if you're talking about a shooting case, I mean, my first question is, was there a gun present? I think practical advice, if a family member of mine is a police officer, or could be just anybody who carries a gun, you don't want to be in a position, in my opinion, of having shot somebody that is unarmed. I'm not saying that's not legal. I'm not saying that there aren't good situations to do it, but that puts you in a bad position, especially in 2020. If somebody's unarmed, doesn't have a gun, doesn't have a knife, and you just shot them to death, then yeah, the facts are already stacked against you. Again, not saying it doesn't fit within the cases. Houses Lost Tribe. Love the segment of qualified immunity. Appreciate it. Patrick, nobody talks about civil rights. Go try to find a civil rights lawyer in your area. Yep, I know. It's difficult. It's difficult for people to find a lawyer in this area of the law because one, it's a specialty of sorts where just your regular lawyer is not going to know much about it. And secondly, it's tough to get somebody that will take on the law enforcement or the power structure. What state am I in? I'm in West Virginia. Let's see. Chesterfield County, Virginia. You know, I don't practice in Virginia. I only practice in West Virginia. Now, if you got something on video that is a really strong case, you know, I have people in Virginia I can work with. But as far as just handling routine cases in Virginia, I don't. They need to be put in jail. Unfortunately, I can only get awards of money damages as a private lawyer. You need a federal prosecutor or a state prosecutor to do that, as I've ranted on before. Let's see. Daniel, stuff is heating up now on the East Coast. Houses, I appreciate the referral. I think qualified immunity is the most misunderstood concept that there is in this area of the law. Last chance, that's right, West Virginia. But a lot of the Fourth Circuit stuff that I'm talking about, that applies to everywhere in the Fourth Circuit, which is West Virginia, Maryland, North Carolina, and South Carolina. I'm running out of time here. Let me see if I can find any questions. Okay. Yeah. Blind justice. I keep getting these comments that I need to pay attention to what had happened with blind justice. I appreciate you for joining me, Blind Justice. I did see what happened to you. I did respond to some of the questions that were sent to me. You know, there's not a whole lot that I can do in North Carolina because I don't practice there. But you know, if there's some way that I can help, you know, I'm happy to help. You know, with the amount of time that I have. But I'm glad to hear that you're out anyways. I know that there were a lot of people concerned. Chokehold on Eric Gardner. Yeah. Well, I'd probably do a separate video on chokeholds. I did do one with a friend of mine in the jiu-jitsu world. Peanut, I appreciate that. Take a second, hit the like button. Lawyers are a joke. Well, some of them are, some of them aren't. But like anything else, you get what you pay for, right? West Virginia Legal Aid doesn't want to touch stuff like this. Well, you know, they just got $830,000 from our governor. Last time I checked, that was a job of the legislature to appropriate money. But since he's, you know, when the parents are away, the kids will play. Since the legislature's out, our governor is now the czar of our state. He gave $830,000 to legal aid. And I had just commented, you know, the only time I've seen them is in divorce cases. And why not get involved in civil rights cases? But they don't. And ACLU, same thing. You won't see the ACLU helping anybody in this area of the law. And again, that's, you know, they get money, but they're doing the social justice warrior thing right now. Do I have a video on supremacy clause? No, I don't. But I took a poll, and excessive force won the poll. And excessive force really is, I mean, hell, that's what I do the most. I love taking excessive force cases because you don't get qualified immunity generally. It's easy to take them to trial, and usually they settle. All right, so thanks for watching episode 20 of Freedom is Scary. I have to get back to work here. And also, I'm doing a live video tonight at 5:00 p.m., a freedom rally, an open the state rally with West Virginia independent gubernatorial candidate S. Marshall Wilson, and we're doing that at my Lewisburg, West Virginia office. And we're going to do it live on YouTube and Facebook, and also live in person. We're going to talk about the tyranny of our governor and locking down our state and depriving us of our representation in the legislature. So I encourage you to watch that at 5:00 p.m. tonight Eastern. If you are in West Virginia, he needs your vote. Independent write-in candidate for governor, and he's saying a lot of great things, and he is a defender of the Constitution. So I encourage you to watch that if you're in West Virginia. So again, thanks for watching. Why is freedom scary? Because through the guise of safety, that's how government takes our liberties. William Pitt the Younger said, "Necessity is the plea for every infringement of human freedom. It's the argument of tyrants. It's the creed of slaves." Don't forget to subscribe for more videos. Also, subscribe on the civilrightslawyer.com for updates on cases and updates of new videos. And I appreciate you watching, and I'll see you next time.